guilty or not guilty, dangerous or not dangerous. This is a question that is open to interpretation. So how dogs get labeled is a really big focus for me as a defense lawyer in these cases. And we're looking often at a patchwork of municipal and provincial laws, and we're looking at mostly dog infractions. You don't get a lot of cat cases. They do come up once in a while. They do. But so we've, I think, gone over the primary laws. I'm not gonna belabor that here. But the definitions allow for an animal control officer to have the authority to seize, impound, and detain dogs deemed dangerous. They can apply for court orders for destruction if a dog poses an unacceptable risk. And as David said, Santix is the case for that. So underlying the statutory framework is an important facet here, because dogs are now, in the last, I'd say, especially from the colonial point of view, dogs are to be regulated by the state. And that's the legal frame and the lens that we're looking at these cases through. So what I say is that the conduct of the dog is overemphasized, and we don't have enough attention put onto the behavior of the owner, because both dogs and humans need socialization. Humans are more amenable to being able to read and understand educative parts of what they should be doing in a park, for example. And a bad owner will be a bad owner regardless of how many animals he's had put down as being aggressive or dangerous. So I think a negligence-based regime is something that we should incorporate going forward if we can. And I think it's more reasonable and educative for both humans and dogs, and we can save more dog lives that way. So the overarching goal, in my view, is balancing public safety with the rights and responsibilities of dog owners. And this is where the tension exists between the rights and the responsibilities and the public and the authorities who enforce the law, as we see in our dangerous dog cases. So that's a picture of Punky Santix. I love this quote from a BC Supreme Court judge. No lineup, photo, or otherwise for Robbie. No charge, no dramatic reading of the Canine Charter of Rights and Freedoms. No plea, no trial, no application of the ancient and historic presumption of innocence. No appeal to the majesty of the Court of Appeal. Guilt or innocence, undetermined. Robbie faced the ignominy of almost immediate oblivion. Thus, Robbie was taken to the Langley Pound, which, in the eyes of some, at least Robbie, is a far cry from the warmth, solicitude, and understanding of home and hearth, and which to him was indeed the equivalent of a canine gulag. So you have a BC Supreme Court judge describing the situation of a dog who is seized. So Robbie, being basically powerless, totally dependent on human decisions, hanging out in a canine gulag, facing almost immediate oblivion. This is not a pleasant situation. These cases are really, really serious. And when I've been handling these cases, it affects the person's life. They're consumed by these cases, actually. So having a dog on death row facing euthanasia for violating laws is a very, very serious matter. And I think we need to look at these designations more closely. So I'm not going to get into what Section 49 of the Charter says. You can come back and read this in more detail. But what is interesting is the wide discretionary power to designate dangerous dogs, often without a medical examination by a vet, which I find is something that we should be doing. Given the scope of discretion and the fact that a family member can be killed and seriously injured is also not defined in the statute.